Losing a family member is hard enough as it is. It becomes even more difficult when there's a will that's discovered that seems suspicious, that seems out of character for the deceased loved person. And oftentimes we're consulted about the possibility of contesting a will, of disputing whether that will is valid. And there's multiple reasons why a will could be deemed invalid under the law. First and foremost, or one of the things that happens most often, is the person believes, our client believes, that when that will was signed, their loved one did not have the mental capacity to sign the will. It could be because they had dementia, Alzheimer's, had been under the influence of really heavy medications following a surgery or difficult treatment. So under those types of situations, if a person mentally does not understand what they're doing at the time they sign that will, then that will should be deemed invalid because they didn't understand what they were doing. Another reason that's somewhat related is when a will is what's called procured by virtue of undue influence, meaning that somebody pressured that person to signing the will in different ways, right? So an example is there's a caretaker, whether they're a family member or not, that there's a person that takes care of that individual, and they threaten them with like withholding food or medications and saying, well, sign this will or else do horrible things. Taking it to an extreme, like holding a gun to a person's head or something, right? That's obviously that person did not intend to sign that will. It's not what they really wanted, and so they were unduly influenced. It could take some more subtle forms, right? Holding that person from seeing family members, right? And then lying to them about, hey, well, your son, your daughter, your niece, nephew, the person that you wanted to leave something to, well, they don't care about you. They're not trying to see you, right? And really the person's just being sort of sequestered, right? So those are the two main reasons why a will could be deemed invalid. There are certain things like, well, was it procured by fraud, right? Was the will forged? So essentially what the law is trying to do is making sure that that will was signed by the person, right? Or under their direction, right? If somebody's blind, they can't direct somebody else to sign, but that will was the intention of the person who signed it, right? Who wanted that will done, right? That's really the core of all of these disputes, was that the true intention of the person that created the will. So what does a process look like? Well, for starters, a will contest is plain old litigation, right? The probate court is not really a separate court, it's part of the regular civil court, it's just a division within the civil court where litigation often happens. So when there is a will contest, the person contesting the will is filing a lawsuit against whoever else is involved, right? And they're asking the court to declare the will invalid. So it starts like any other lawsuit where you file a complaint, you have to serve the people involved with the complaint. It works under the rules of civil procedure, meaning it's following along the same process as any other litigation in state court, which means that upon filing the lawsuit and the complaint and serving it upon the other people, they have the ability to try to file a motion to dismiss, or they can respond and present defenses. There's discovery that happens, discovery meaning where you're asking for evidence, right? You're getting medical records, you're asking for communications between people. You can take depositions, so there'll be court hearings, and ultimately end up in a trial. So the process is very similar to any other type of court case. It's just the subject of the lawsuit is whether this will was valid or not. So what can you expect if you're contesting a will is, one, for it to be a lengthy process. The litigation process by design takes some time. Why? To make sure that people have the opportunity to get the evidence that they need to prove their case or to defend themselves, and to make sure that ultimately the right decision is made. So it's not done extremely rushed. Don't expect it to be done in a week or a month. And it's often taking several months, a year, 2 years, right? So does take a long time, can be frustrating and costly. And sometimes it's worth it. Of course, like any other lawsuit, it can be settled. So you could go to mediation, you could negotiate with the other side and ultimately reach a negotiated solution, just like you can in any other civil case. Those are the things that can happen if you're going to be contesting a will. Strongly recommend that you do so with an attorney, because if you're going to court, you should be represented by an attorney. We at Perez-Roura Law do take part in probate litigation and will contests and other types of probate litigation. So if you believe that there is a will that has been procured by fraud, or you're being accused of such, you can call us. The consultation is confidential, so you can speak to us openly about what you did or didn't do, or what you believe happened. And certainly those conversations are completely confidential, and ultimately so you can decide how you want to proceed with your case. So you may reach us at 305-359-3888 to schedule your consultation. Thank you.